this meeting to order. Welcome to meeting number 105 of the House of Commons Standing Committee on Access to Information, Privacy and Ethics. Pursuant to Standing Order 1083H and the motion adopted by the committee on Monday, October 30th, 2023, the committee is commencing its study on the decision of the Royal Canadian Mounted Police to not pursue a criminal investigation in relation to the SNC-Lavalin affair. Today's meeting is taking place in a hybrid format pursuant to the standing orders. Members are attending in person in the room and remotely using the Zoom application.
Remind everyone, as I always do, that the microphones could cause feedback and potential injury to our interpreters, so please make sure that they are away from the microphone. I'd now like to welcome our witnesses for today. From the Royal Canadian Mounted Police, Michael Duhaime, who is the Commissioner. Sir, welcome to committee. And Frédéric Pinsance, who is a Staff Sergeant, Sensitive and International Investigations, Federal Policing, Ontario Division. Just before we start with your opening statement, Mr. Duhaime, we've got 2 hours of the Royal Canadian Mounted Police being here today, as is custom practice, and I'm going to seek unanimous consent on this. If we can reset the clock on the top of the hour to give the bloc and the NDP the opportunity for another 6 minutes. Do I have unanimous consent on the part of the committee to do that? Okay, thank you. Mr. Duhaime, you have up to 5 minutes to address the committee. Please start, sir.
Thank you, Mr. Chair. Good afternoon, honourable members of the committee. It's nice to be back. Thank you for the opportunity to speak to you today. I'm joined here with by Acting Officer in Charge, Staff Sergeant Fred Pinsance from the RCMP Federal Policing Sensitive and International Investigation. Tout d'abord, j'aimerais prendre un moment pour parler du...
First, I would like to take a moment to speak about the RCMP's federal policing role. Federal policing has a multifaceted mandate with authorities under more than 250 federal statutes and acts of Parliament. We enforce federal laws, investigate criminal activity related to national security, transnational and serious organized crime, financial crime, and corruption. Also, we secure Canada's borders and ensure the safety of critical infrastructure, internationally protected persons, other designated persons, and democratic institutions. Federal Policing's Sensitive and International Investigation Section has the mandate to investigate sensitive, high-risk matters that cause significant threats to Canada's political, economic, and social integrity both across Canada and internationally. This includes allegations of fraud, financial crimes, corruption, and breach of trust made against elected officials, senators, or executives of the federal government.
Following media reporting of the allegation of political interference in February 2019, the RCMP began monitoring the matter to determine if a criminal investigation was warranted. As the committee is aware, the former Attorney General made public statements about the alleged political interference before the House of Commons Standing Committee on Justice and Human Rights and was authorized to do so by an order in council. Dans le cadre de son évaluation, la GRC s'est entretenue.
In its assessment, the RCMP reviewed and assessed the relevant testimonies and did this in an objective manner. The RCMP reviewed and assessed the relevant testimonies before the House of Commons Standing Committee on Justice and Human Rights and reviewed publicly available documents providing additional context on the matter. This included the report from the Honourable Anne McLellan on the review of the roles of the Minister of Justice and Attorney General of Canada and the Trudeau II report released by the Office of the Conflict of Interest and Ethics Commissioner. This review was followed by interviews with key witnesses, some of which were from the Office of the Minister of Justice and Attorney General, including the former Attorney General, and a review of disclosed documents.
These interviews, the RCMP was subject to the same parameters that had applied to the former Attorney General's testimony before the House of Commons. An order in council which waives solicitor-client privilege and any other relevant duty of confidentiality to the Government of Canada relating to the exercise of the authority of the Attorney General respecting the prosecution of SNC-Lavalin. Based on all the information gathered and reviewed by the RCMP, it was determined there was insufficient evidence to substantiate a criminal offense, and insufficient evidence to support taking further investigative steps. An additional consideration in the RCMP's decision was the impact on the continuing privilege and the limited scope of the waivers of these privilege. These would have a significant impact on the ability to gather evidence and prosecute charges. That said, notwithstanding the privilege barriers, the RCMP assessed there was insufficient evidence to proceed. Je vous remercie de m'avoir donné l'occasion d'être ici aujourd'hui.
Thank you for the opportunity to be here today. I welcome any questions you might have.
Monsieur Duhaime, on va commencer.
Thank you, Mr. Duhaime. We're going to start with our first round for 6 minutes. Mr. Brock.
Let's go ahead, please.
Thank you, Chair, and good morning, Commissioner. Good morning, Sergeant. Thank you for your attendance. I hope your attendance today is fulsome, that we get through the full committee without receiving a notice of motion to adjourn. At the heart of the SNC-Lavalin scandal, there were a number of players within the PMO, the PCO, and the Ministry of Finance. However, the principal person of interest in the SNC scandal was at all material times the Prime Minister, Justin Trudeau. To you, Commissioner, the scandal is now over 5 years old. When did the RCMP interview Justin Trudeau?
I'll let Mr. Pain-Saints further discuss about the interviews, but it is 5 years old, and the matter was brought to our attention in 2019 and officially concluded in January 2023, in which we notified Madame Wilson-Raybould as well as Mr. Scheer, who had written a letter to the Commissioner Lucky at the time.
Thank you, Commissioner. The question was very specific. How many times in the last 5 years did you interview Justin Trudeau?
He was not interviewed, sir, or Mr. President.
Okay, and why not?
I'll ask Mr. Pain-Saints, who was leading the investigation, to add a little bit.
Yes, thank you, Mr. Chair. So, in relation to this, what the RCMP conducted as far as for the objective for the review of the matter, what we've done is we've proceeded with a phased approach, which initially we looked at the potential witnesses that could provide some information as far as to precision for the elements of the offense. So we proceeded in this phased approach. As we proceeded, we determined if there was any further investigative steps that
Sergeant,
were warranted given the
Sergeant,
circumstances of the case.
My time is very limited. Why did you not interview the primary person of interest? At the heart of this investigation was Justin Trudeau's political interference for his own personal gain and the gain of SNC-Lavalin. I can inform both of you, gentlemen, that in my over 30 years of experience as a defense counsel and as a Crown attorney, I have never heard of any investigation where there wasn't any attempt, whether they agreed to interview or not, any attempt to interview the person of interest. Was there at least an attempt to interview Justin Trudeau, yes or no?
No.
Did the RCMP obtain all relevant documents to further the investigation, including access to cabinet confidential information, simply seeking a yes or no response?
We were limited with the information that we had access to.
Was that a yes or a no, sir?
I don't know. We didn't know. We don't know. We still don't know to this day all the information that's out there because some was protected.
I'll take that as a no. Despite collecting reams of evidence, including evidence from the Ethics Commissioner and testimony from Jody Wilson-Raybould at committee, why didn't the RCMP exercise its absolute statutory right under the Criminal Code of Canada to obtain a production order and/or search warrant from a justice to obtain those cabinet documents?
We weren't able to acquire or obtain enough information or evidence that would warrant us to obtain a production order.
RCMP spokesperson Christy Veenstra is on record stating that to obtain a search warrant or production order, there must be reasonable grounds to believe that a criminal offense has been committed. The evidence at hand is sufficient to convince a trier of fact. The evidence at hand is insufficient to convince a trier of fact of the alleged offense. Clearly, she is conflating the legal threshold of policing with the Crown Prosecution Service. Both of you, sirs, will agree that your sole responsibility is to determine whether there are reasonable and probable grounds to lay a charge. It is not your mandate to prove the charge beyond a reasonable doubt, which is the independent prosecution service. Would you agree with that?
I agree, Mr. Chair.
Thank you. Was obstruction of justice involving Justin Trudeau the only offense you were contemplating in this regard?
No, there's also intimidation of a justice participant.
Thank you. You would agree that the charge of obstruction is a straight indictable offense, meaning there is no limitation period, punishable by 10 years in prison, a very serious offense. You'd agree, sirs, that there is nothing precluding your service from reopening the investigation against Justin Trudeau should new evidence become available, including a release of cabinet confidential information.
I would say, Mr. Chair, with any investigation, when there's new information that arises, yes, we have a look at the investigation itself.
To quell public concern, Justin Trudeau, despite his office, is subject to the full impact and consequences of the Criminal Code of Canada. He is not above the law, correct?
I do believe I said that last time I was in front of the committee. No one's above the law.
In my experience, sirs, homicides have been investigated and prosecuted in lesser time than your service has invested in investigating Justin Trudeau. Is there an overall general reluctance in charging a sitting prime minister, yes or no?
I would say to that, Mr. Chair, is that we follow the evidence, and if the evidence warrants charges, we charge.
So there's no general reluctance in charging a sitting prime minister. Is that correct?
If the appropriate evidence is available.
Thank you. You would agree that the purpose behind the offense of obstruction of justice is to maintain the integrity of the justice system and upholding the rule of law, that all the principles that were articulated in Jody Wilson-Raybould's testimony in warding off Justin Trudeau's relentless campaign of pressure and intimidation. You'll agree with me, Commissioner, the evidence is clear. This is not a one-off. Over the course of 4 months...
Sorry, Mr. Brock, but we're over time here.
Thank you.
Okay, thank you. Next, we're going to go to Mr. Housefather for 6 minutes. Go ahead, please.
Thank you very much, Mr. Chair. Commissioners, for coming today. Thank you for coming today. I'm going to start by asking you, was the way that you investigated these allegations any different than the way the RCMP would investigate other allegations? Were you holding yourselves to a different standard?
No, I'd invite Mr. Pincens to add, but we approach every investigation the same manner.
Exactly. I confirm, so Mr. Chair, yes, we proceed by following where the evidence leads us.
And it's not politicians to dictate to you how to do your jobs as the RCMP. You guys are the experts in terms of doing these investigations, correct, I would think?
I can assure you that, Mr. Chair, we've never been dictated by a politician how to do our job.
And you received no pressure in this case to close the investigation from the Prime Minister or his office or anyone else in government?
Not at all.
Thank you so much. And let me ask another question. When this was characterized as an investigation of Justin Trudeau by Mr. Brock, in my view, this wasn't an investigation particularly of Justin Trudeau. It was an investigation of all the circumstances, and you would have taken yourselves in the direction of if anyone that you had investigated had broken the law, you would have recommended charges against them, right?
That's correct. And I might add, Mr. Chair, is that when the first article appeared in the Globe and Mail, I was the commanding officer of the National Division, and I actually reached out to Sensitive International Investigation. I said, let's monitor what's going on here because it might end up in our wheelhouse.
100%. So you yourselves, as I understand in 2019, initiated a review based on the article in the Globe and Mail and then followed the Justice Committee, which I have all too many memories of at the time, correct?
Correct.
And my understanding is that, you know, there was a look by the Ethics Commissioner at this. And I want to make clear something, and perhaps you could also characterize that. When you breach the ethics code, and politicians have frequently breached this ethics code, it doesn't mean you're necessarily committing a criminal act, correct?
That's correct.
And could you sort of explain to us the difference between committing a criminal act versus a breach of the ethics code?
Well, if you look at the threshold for a criminal act, you need the right evidence to get the legal documents to allow you to do production order or a search warrant to eventually lay the charges, if there are charges to be laid. I must say that the commissioner for the commissioner does have power with regards to in his search, in his review or ethics review, if he does come across any criminal matters, he's to refer them to the RCMP. And in this case, the ethics commissioner, which had more access to more information than the RCMP, did not refer anything to us.
Correct. And as I recall, in her testimony before the Justice Committee, Ms. Wilson-Raybould was asked this very question, if a criminal act had been committed, and it was her view that a criminal act had not been committed, correct?
She stated that it was inappropriate, she felt it was inappropriate behavior, but not criminal.
Thank you. And in paragraph 22 of the document that I believe Mr. Pensis was one of the signatories to, it says, notwithstanding the privilege barriers, it is believed that there is insufficient evidence to obtain production orders or search warrants for additional materials based on the totality of the circumstances and the evidence gathered. When factoring the principles of full, fair, and frank disclosure of the matter, it is believed that the evidence at hand is insufficient to convince a trier of fact of the alleged offenses. So meaning that you believe that the threshold had not only not been reached to criminally prosecute at this point, you didn't even believe a threshold had been reached to ask for further production of materials. Could you sort of explain that to me?
So yes, Mr. Chair, so in relation to this, for us to obtain any form of judicial authorization, there are some preconditions within the criminal code that we have to follow, and that's exactly what we've done in this case. So these preconditions were not met, which in this case would be that we had insufficient information to substantiate an offense, which is one of the preconditions. So as such, this option, as allowed by the criminal code, was not available to us.
And that would be true of both of the different charges that you were looking at, correct?
Yes, sir.
One last question. My understanding is from reading the documents you provided that you did not feel that criminal intent, which is an important element of committing a criminal offense in this case, was found, or that you couldn't substantiate that it was found to a level that would allow for prosecution. Is that also correct?
That's correct, Mr. Chair.
Mr. Chair, do I have any time left?
You have a minute and 15 seconds.
Okay. I would like to ask also, is there anything else that you would like to clarify based on the original questioning from Mr. Brock that I have not allowed you at this point to clarify in terms of where you were asked to answer yes or no?
Not at this time, then, Mr. Chair.
Okay, perfect. So one last question. When the RCMP made a determination not to interview certain people or to interview certain people in this case, including the Prime Minister, did you base that on your normal standard of policing, based on the way you would have handled other investigations as well?
That's correct, Mr. Chair.
You did not accord him any undue deference because of the office that he held?
No.
Okay. Thank you, Mr. Chair.
Okay, thank you, Mr. Housefather. Monsieur Villemure, pour 6 minutes, s'il vous plaît. Commencez.
Merci.
Thank you, Mr. Chair. Thank you to the witnesses for being with us. I will ask a completely different question. There have been many allegations over the years against Trudeau, and this has an impact on Canadians' trust with the Prime Minister. And this trust is important. And we rely on the RCMP to shed a light on things. The Ethics Commissioner did not believe it necessary to go further. That was a decision that he made to not seek the assistance of the RCMP. Whether or not it's a good decision, we're not sure. But earlier you said two things, that warrants were limited and you didn't have enough evidence to go forward. Did this force the end of an investigation or stop an investigation from starting, or was it enough to say, we've got enough? Mr. Chair, if we look at the information that was available, a lot of it was solicitor-client privilege and cabinet confidence. And in order to get a search warrant, we need credible information, yes, but that would allow us to get a legal document to move forward with a search warrant. And in this case, with the information that we had, it was not possible to get the legal documents that would allow us to get that warrant. Was that information lacking, or Was it simply that it did not justify going further? Answer. It didn't justify going further to have access to the documents. So in your view, the thing to do was to say, well, we can't get more information because we don't have the basic elements, and so the investigation is closed. We would close the investigation unless new information was to surface. I know that this isn't directly in your job description, but I really focus on public trust. There are acts that can be legal but non-ethical, and the impression was that there was no legal issue, but ethically it was iffy. Canadians are still talking about this issue, and trust has been broken. And trust is something that needs to be protected. You're at the head of the RCMP as the commissioner. I know that trust is not part of your job description, but what do you think about that? As an RCMP commissioner, it's important to have the public's trust when we're carrying out investigations. I won't comment on the ethics or trust of the government, but I can say that our team used all the tools at their disposal to have access to the information needed in order to get as far as we could with the investigation, and we didn't have enough to go forward. Well, you're saying you couldn't go forward with the investigation, and I think that that's where the breaking of trust happens, because the Prime Minister has not been exactly ethical, and it's that doubt that he creates that has an impact on public trust. And I would like to know what our committee could do to eliminate that doubt. Do you have any documents that you could share with us? I'm not aware of any documents other than the report, but if the question has to do with ethics and the government and the Prime Minister, that's not something I can comment on. For the RCMP, well, for us, it's important to have the public's trust for investigations. If we look at the SNC Lavalin file, if we look at the team and Fred and his team and what they have done, you can see how professional they were. You talked about intimidation earlier. Can you tell us more? At the beginning of the investigation, we collect information that's available, and we were looking at two accusations: the obstruction and intimidation. And you didn't move forward with the intimidation. With all the criminal code accusations, we have to meet certain criteria, and in both cases we did not meet the threshold to investigate. Thank you very much. Thank you, Monsieur Villemur.
6 minutes. Go ahead, please.
Thank you very much. I just want to get a better understanding. I heard in your testimony today that you were approaching this in a phased approach. And I think that I'd heard that there's a difference between probably an assessment and an investigation. Is that correct? Can you just explain the difference between an assessment and investigation?
Yes, absolutely. So, Mr. Chair, so when the matter was first came to light from the media articles, the testimonies before the committees, we looked into this. And of course, we followed all of this information to try to determine if a criminal offense has taken place. So, of course, we followed the testimony from the former Attorney General, the Honorable Ms. Wilson-Raybould, and we looked at the information that came from this one. So, of course, as you well know from the testimony at this point, the question was posed as far as the criminal element into this whole situation. And, of course, we all know the answer that was provided at that time. So, of course, now we're still reviewing and assessing further information to try, again, to determine if a criminal offense has taken place, hence the phased approach. So we assess the information And then
And through your testimony, we've determined that you can't make that assessment because foundational information isn't made available to you. In February 2019, the government issued an order in council, which was 2019-0105, which waived in part cabinet confidence and solicitor-client privilege in order to allow for the Minister Wilson-Raybould to testify at the Justice Committee. Did you request an expansion of the OIC to allow you greater access to personal testimony and documentation?
yes, we did, Mr. Chair.
And I'm sure one of the frustrations that I have, and I know that the Honourable Ms. Wilson-Raybould also suggested this, that in her role, she was both the client and solicitor. And in fact, that is one of the challenges that we have, where we have a government that consistently, this is my opinion, by the way, I'm not putting this onto you, claims both the client and the solicitor privilege on all matters, claims confidence on all, or cabinet confidence on all matters. So when dealing with a scenario where the institution under investigation is, by virtue of its institution, both the client and the solicitor, how do you navigate getting any kind of information from them?
Those are the parameters we deal with. The team itself had requested additional information, and it was refused. And like I said, those are the parameters we operate in. I could say there's something similar when we navigate in national security space with information that we can use and can't use.
And it's still your assertion that applying for a court search warrant for the Trudeau cabinet documents and records of communication, that you didn't have sufficient evidence to even begin that?
We didn't have sufficient information even to entertain to go to production order or even a search warrant.
So then why did you wait almost 2 years to end your examination of the situation without having the ability to do a full investigation?
So there's a couple things there where the sensitive international investigation wrapped everything up in spring 2021. And there was a change in management at several levels, and that's on us, and we looked into it, we corrected that. There's probably 10 months there that it could have been done in a shorter time. It's just a change in management, and the reporting made it that we informed Madame Wilson-Raybould in January 2023, and subsequently Mr. Scheer by way of a letter.
And where would you have been in that decision-making matrix?
I was Deputy Commissioner of Federal Policing, so there would be a program manager reporting to me, and then the team would be reporting into 3 different levels before getting to me.
Okay, so you would have been involved in making the delay decision?
It's not a delayed decision. It's just it was the change of resources within the organization made it that when it got to me, I presented to the commissioner and then forwarded.
Certainly, you can appreciate that on the outside, having had 2 elections within a period where this was highly contentious, the timing for the general public, I think, leads to, whether necessarily so or unnecessarily so, theories of cover-up, theories of delay, theories of political interference and timing, because, again, to the same effects that you don't have access to information, it's my assertion that when the public doesn't have access to good information, they're led down these paths. So was it also you who would have ultimately made the decision on whether to prosecute or not?
Ultimately, I rely on the subject matter experts from the union, from the unit. But I just want to go back to the question there, not the question, but the comment, Mr. Chair, is that at no time did we brief the minister or the PM or any political appointed individual on this file. So to even suggest that this was delayed, they didn't even know at what stage we're at with the investigation, delayed because of elections. It was on us. I admit there's a mistake on us that it could have moved forward, and we corrected that.
And so back to my question, would you ultimately have been the person to decide whether to prosecute or not prosecute?
I would sit down. Ultimately, we would have a discussion with the Crown Prosecutor assigned to the file and have a discussion. But within the team here, I'd be sitting down with our folks and being guided by our subject matter experts.
Okay. Just to be clear, you're the commissioner now.
I'm the commissioner now.
Okay. And I'm just asking you to take some leadership now. Okay. Ultimately, on your end, would the decision have been yours, or would you have reported to somebody else to make the decision?
It would be. I wouldn't delegate it down, but every charge doesn't come up to me for approval.
But certainly one involving the Prime Minister would likely have your approval.
I would be informed and I'd be supportive, but it's not every charge that makes its way up to the Commissioner.
But certainly, I think, like look, let's just be frank. You have a duty of candor. I'm going to extend that duty to this committee. I need you to be candid and take responsibility if you were the one to make the decision or if you would have reported up to somebody to make the decision. Ultimately, there would have been somebody sign off at some point in time. If there's a chain of command in our paramilitary policing units, there's a chain of command that you would have been a part of. Did you make the decision, yes or no?
I would have been guided by my subject matter experts and supporting that. So obviously, if we're charging the Prime Minister, for sure, you'd be on board.
Thank you. I did give you a little bit of Mr. Housefather's time because he was short. So that completes our first 6-minute round. Just to advise members of the committee that about an hour before the committee commenced, we received correspondence from Democracy Watch. It did come in both official languages, but it wasn't distributed to the committee because, per the routine proceedings, the motions that were adopted in December, I asked the clerk to conduct a linguistic review. It's being done now. Once it's confirmed by translation, the French version of it, then I will distribute it to the committee as well. Okay, there was a series of questions that Mr. Conacher had submitted. So, that being said, we're going to go to our second round, 5 minutes. We're going to start with Mr. Barrett. Go ahead.
I have questions for you that come from an access to information request. It's ATIP A-2021-02029. It deals with a decision tree from Section 121(1)(c) of the Criminal Code, fraud on government. I provided both you, Commissioner, and the Staff Sergeant with this just before the meeting started, just as we moved through the document. So in this decision tree, it asks a series of questions. The first question, was Mr. Trudeau a government official at the time that he took a vacation to Bell's Cay?
Go ahead on the point of order, Ms. Khalid.
I realize that the witnesses have documents and Mr. Barrett has, but we would like to also follow along, if that's okay, if Mr. Barrett can share them.
Okay, the challenge
On that point of order?
On the point, Mr. Barrett.
Yeah, I'd be happy to provide them to the clerk. They'll go into translation, and then they'll be furnished to other members of the committee. It wasn't proactively disclosed by the government. It was made available by ATIP. But I don't have any questions for other members of the committee, so they don't need a copy of it. If they would like to email me and ask for an English-only copy, I can furnish them with that, but I don't have it in French. I will provide it to the clerk. Translation services can deal with it, but I'd like to continue with my questions, Chair. It's not required for me to provide other members of the committee with documents that are provided to witnesses. It's not in the standing orders.
So I'm going to ask that Mr. Barrett furnish that to the clerk so that we can have it translated and supplied. If he's only referencing it for the purposes of asking questions, I don't see, it's not a document that's submitted to the committee for that purpose. He's referring to.
Yeah.
Okay, so I mean, if that's the case, if the witnesses have it and Mr. Barrett has it, we as members of the committee should be able to look at it too while these questions are going on. I'm not sure if my colleagues agree, but I'm a little bit lost without having this document in front of me, so I can follow along too.
So I'm going to allow this to occur. Mr. Barrett will be referring to the documents, I assume, you mean, based on your first question.
I'd like to finish my first question, yes.
Right. You're going to complete your first question. But the point I'm making, Ms. Khalid, is that he can reference, just as any other member has paper in front of them that's not shared with other members of the committee. This is an access to information document that he has in his possession. He'll be reading from that document, I assume, and that will be translated at a time. So I don't really see the need for other members of the committee to have that. Yeah.
Thanks, Chair. The difference is that we don't share our questions or our comments with witnesses prior to us asking them. And in this instance, those documents have been shared with the witnesses. So I don't know if my colleagues want to jump in here.
I'm going to go to Mr. Barrett first and then Mr. Green on the point of order.
Sure, Chair. It was provided to the witnesses at the start of the committee meeting. It's an RCMP document. They provided it in the ATIP. But if it makes other members of the committee uncomfortable that the RCMP are able to follow along, then I would just kindly ask for the clerk to collect the document from the witnesses, and I'll continue with my questions.
Okay, so just just received clarification. We cannot distribute those documents because, from what I understand, they are in one language. But if Mr. Barrett wants to distribute that to other members of the committee in that one language, then you can have that document in front of you if that's what the preference is on your side or any other side. So, no, Mr. Villemure says no. So can we collect the documents from the witnesses then, Mr. Barrett, and then? Sorry. You are? Yeah.
Thank you.
Yeah, if the Liberals don't want the RCMP to see the decision tree,
So sorry, Chair,
then
I can't allow those kind of statements.
If the Liberals,
Chair, I raised a point
if I
that
have the
is of
floor, I have the
procedure
floor,
in this
and I have
committee.
the floor.
Yeah,
And I
so
still, if the
just-
Liberals
just
do
hang
not
on.
want the witnesses to have the documents, then I'll leave it to the chair to instruct the clerk to collect them, but I'd like to finish my questions.
Okay, so I'm going to instruct the clerk to collect the documents.
Mr. Chair,
Go ahead.
respectfully, before you
Go ahead,
make
Mr. Green.
decisions
On the same
point of
I
order,
apologize. Go ahead.
respecting the standing orders, I'm duly accorded the time. I would suggest, so that we're not setting a dangerous precedent in terms of what expectations are, I would suggest that each of us have, through our own offices, the ability to do research, to do preparation for committee. And while it might be a courtesy that could be extended from time to time, I would just go on the record to state I surely would have no expectations of any party, both government, opposition side, to provide me with their homework in advance. I'll just state that.
Mm-hmm.
So I'm a bit uncomfortable that we're going to start to put constraints on, and I'm saying this objectively because it could happen to any one of us down the line. If we've done the work and we've gone through ATIPs and done all the stuff, as New Democrats, we don't necessarily have the resources to have big research policy bureaus, so we're doing it on our own with our incredible team behind me here. I just want to make sure that we're recognizing this would be a courtesy and not some kind of precedent in this committee where we're going to start having to share our homework, because I have no interest in that. Thank you.
Yeah, and I appreciate that, Mr. Green. And I guess if we want to broaden that a little bit, the challenge runs with the risk is that, there are other articles. This is an ATIP article, but there are Globe and Mail articles. There are CBC articles that people refer to all the time, but that are used in the line of questioning. So, Mr. Brock, I saw your hand up on the same point of order. Before I make a decision on where we're going to go, I think I've already made the decision, but go ahead, Mr. Brock.
Very quickly, what my friend Mr. Barrett was referencing comes out of the David Watts Manual of Jury Instructions. Any member can Google that manual and find that tree that Mr. Barrett is referring to.
So, I'm going to ask the clerk, Mr. Duhaime. Mr. Barrett is going to reference to the document in question. I'm going to ask the clerk to collect the document if that's okay. And then, Mr. Barrett, if you want to continue on your line of questioning, I think you'll give the commissioner and Mr. Pinsance a pretty good indication of what's on the document. So I'm going to ask you to go ahead. I've stopped your time. You've got 4 minutes.
Sorry, Chair. I don't need the witnesses to give their documents back. It's absolutely fine, but I did want to raise this as a point because when we are giving documents to witnesses, we should be very mindful as to how those documents are circulated to the rest of the committee. In this instance, I'm fine if they can reference those documents at this time.
Okay, so I thought the original intent of your interjection was to not have those documents in the hands of the witnesses. So go ahead.
My original interjection, Chair, was that we can't see the documents that the witnesses and Mr. Barrett were referring to. Having listened to the comments of my colleagues, I'm okay with it this time, but I'm hoping that this does not become a common occurrence.
Okay, thank you. Keep the documents, Mr. Duhaime, Mr. Pinsance. Mr. Barrett is going to reference those documents. Mr. Barrett, 4 minutes and 17 seconds. I'm starting your clock now. Go ahead.
Yeah, I don't need the approval of Liberal members for the material that I'm going to ask questions on. This one's very straightforward. It's a decision tree on Section 121(1)(c) of the Criminal Code, Fraud on Government. It's by the RCMP, and they've populated information on the document. It asks a series of questions with respect to Justin Trudeau's visit to the Aga Khan Island, Bells Cay. Was Mr. Trudeau a government official at the time? And it says yes. Did Mr. Trudeau accept a benefit from the Aga Khan? It says yes. Did the Aga Khan have dealings with the government? It says yes. Then it says, did Mr. Trudeau have consent in writing of the head of a branch of government for whom he worked? It says unknown. At that point, it says, if yes, then the final verdict would be not guilty. But it goes on, if no, did Mr. Trudeau know that he accepted was a benefit from a person who had dealings with the government? Yes. And then if yes, it says, final verdict, guilty of fraud on the government. Now, we know that, in fact, Mr. Trudeau did not have a writing from the head of branch of the government for whom he worked, because that question was put to him in the House of Commons. He was asked, in the House, it was asked, did the Prime Minister give himself permission to take that free holiday in 2016, to which Justin Trudeau replied, Mr. Speaker, no. He was asked again on April 26, 2022. Again, the answer was no. So Conservatives put the question to the Prime Minister to answer the only open question on whether or not the RCMP should lay a charge of fraud on government against Prime Minister Justin Trudeau in the case of his illegal vacation to Bell's Cay. Now, illegal it was certainly law-breaking in that it broke the Conflict of Interest Act. The question is, did it break Section 121(1)(c) of the Criminal Code? Commissioner, did the RCMP call Mr. Trudeau and ask him the question?
I would have to ask Mr. Pinsins, because I wasn't getting ready for the Aga Khan file, and I'm not as familiar with the Aga Khan file as we are with the Jody Wilson report.
Staff Sergeant?
Yes, so, Mr. Chair, so all I should have to point in relation to this specific decision tree is, of course, this is one part of a multiple pages document, so of course this is only an excised part of this. And now to answer the question as far as did we contact the Prime Minister in relation to this one? No.
Okay, so he wasn't asked, and it was left in the document as unknown. And the only open question on whether or not it met the standard of fraud on government. I want to refer to that same ATIP, and a Sergeant Arbor, who was the team lead for SII Team 3, said, quote, if further information of evidentiary value is to be received, SII will review and determine the appropriate course of action.
Go ahead, Mr. Sabera.
Thank you, Chair. Just in terms of MP Barrett's commentary right now, is this pertaining to the actual subject matter we're studying today or not? I'm just going to go for relevance.
I know you've been on this committee for a couple of times. 17 months I've been on this committee as chair, and in every circumstance I allow members to utilize their time in the manner in which they want to. And I expect that Mr. Barrett's going to bring it back, as I expect every other member will do the same thing. So, Mr. Barrett, I really, on the issue of relevance, I've dealt with this many, many times. Okay? I don't want to hear another issue of relevance if we can. If we can avoid that to save time, I would appreciate that. Okay? Mr. Barrett, go ahead, minute and 21 seconds.
Yeah, it's part of a pattern, Chair, from the Liberals, Ms. Khalid, Mr. Sorbera, to interrupt the line of questioning to try and cover up for the Prime Minister, and she's going to do it again right now. On the key question of if Justin Trudeau had consent to engage in the activity, the only question was if Prime Minister Justin Trudeau committed fraud on government. The RCMP didn't pick up the phone, but Conservatives asked him the question, we got the answer. And that answer is publicly available, and it was not protected like transcripts from a committee. So it could be used and has evidentiary value. Knowing that, and knowing based on that decision tree, wouldn't that affect the decision of the RCMP to lay a charge of fraud on government against the Prime Minister if all of the criteria set out in the decision tree from Watt's Manual of Criminal Jury Instruction were satisfied? Wouldn't that new evidence satisfy your investigation?
Again, Mr. Chair, I'm not in a position to say all the evidence that we had or we didn't have. It would warrant a follow-up on that file and come back to this committee explaining what we had on the file and the reasons why we didn't lay any charges. But I'm not in a position right now to say what evidence we had that came to the point that we didn't lay any charges.
Well, with due respect, Commissioner, the only outstanding question on the decision tree provided in the ATIP was whether or not the Prime Minister had consent. The RCMP said it was unknown. We satisfied an answer to that question and that he did not. And based on this document, it says final verdict, guilty of fraud on government.
Thank you, Mr. Barrett. That concludes your 14-minute round. Ms. Khalid, you have 5 minutes. Go ahead.
Thank you very much, Chair. Thank you to the witnesses for coming in. So I'm just going to bring this to your attention, Commissioner. As my colleague across the way was asking questions, he tweeted out I guess, his opinions of how the questions went. He says, breaking news, the RCMP admits they never attempted to interview Justin Trudeau, the primary person of interest in the SNC-Lavalin affair, concerning potential criminal wrongdoing. The RCMP has the power to reopen the SNC-Lavalin and interview Trudeau at any time. Is that the message that you were trying to convey with the questioning with Mr. Brock?
Can you, at the last part of the tweet, I didn't
It
capture
says
that.
the RCMP has the power to reopen the SNC-Lavalin file and interview Trudeau at any time. And there's two photos, one of yourself and one of Mr. Brock as well. I'm just looking for your opinion as to whether that is an accurate portrayal of what you were trying to convey here today.
So I mentioned earlier, as with any criminal investigations that we have, we sometimes close files, and if there's information that comes up a year, 2 years, 3 years down the road, and we're still within that limitation period, yeah, we reopen the file and look at the evidence or the information that's given to us.
So how do you feel that partisan politics, how does that impact the work that you do and your independence?
I would say that nonobstant the parties were independent in what we do. Like I said, and since I've been in the senior positions, I think I briefed the Minister of Public Safety maybe 3 or 4 times throughout the last 5 years, and the PM maybe once or twice. So I don't update them on a regular basis of any of our criminal files, and even less if it's a file that was involving the Prime Minister or even the Minister.
And when politicians direct you or tell you that you should be investigating one thing or another, how do you handle that?
Well, again, every investigation we follow the evidence. And if there's evidence that is given to us or leads, we'll follow up on it. But everything that's given to us we have to be able to use it in a court of law.
Thank you. So with that then, Sergeant Pensens, I'll ask you, can you please tell the committee about the process that was undertaken by the RCMP in terms of how many interviews were conducted and the extensive nature of this whole investigation?
Of course. So, Mr. Chair, of course, the first step that we took was to review the information that was publicly available. So again, these were part of the testimonies before the Justice Committee. We also reviewed information that was publicly in the media. And then following this, of course, because of the limitation that the order in council did not apply to the RCMP, we made a request to obtain such a waiver that would allow us to continue further investigative steps, which is what we did further later on once we obtained a waiver and authorization back in August of 2019. We then proceeded to interview key witnesses which could provide some further information as far as for the nature of the political pressure that took place at that time. And these were the steps that we took from there.
Thank you. And can you share with the committee what piece of evidence, if any, led the RCMP to decide that no criminal investigation was required in the SNC-Lavalin affair?
Yes. So, Mr. Chair, so when we looked at this, we followed similarly we followed the elements of the offense. So we looked at each of the 2 offenses that were before us. We looked at the elements, and then we tried to determine if each of these elements were met. So as we proceed through this, one of the critical elements in the offense of obstruction of justice is, of course, intent to obstruct the course of justice. So, of course, we conducted interviews in order to really assess the information in that regard.
And you found that there was no intention of obstruction, correct?
And then, of course, I have to base this assessment on the totality of the information that we obtained. So again, from the review of documentary evidence that we obtained from these witnesses, from the testimony that they provided to the RCMP, and of course, these were supplemented by all the publicly available information that were provided out there.
Thank you. Now, Commissioner, you had stated that you are very comfortable with the RCMP's decision not to pursue criminal charges in the SNC-Lavalin affair, while confirming that you did not have access to cabinet confidences that you'd requested. Can you explain why you were very comfortable?
very quick response, please.
Report that I receive and knowing the professionalism of our folks at Sensitive International Investigation, I'm comfortable to say that we did everything we can to gain as much information or access to as much information as possible within the confines of the regulations.
Okay, thank you, Mr. Duhaime. Ms. Khalid, just before, en avant de commencer avec M. Villemur.
Before moving on to Mr. Villemur, if participants wish to speak.
Fine. Monsieur Villemur, pour 2 minutes et demie, commencez, s'il vous plaît.
Merci beaucoup, Monsieur le Président.
Thank you very much, Mr. Chair. Is there anything that you would have wanted to obtain to carry out the investigation? Answer. We looked at the 2 possible charges, as my colleague stated earlier, and we have a threshold to meet for those charges. And for any investigation, we want to have the information that we need in order to meet the threshold of these charges, or at least to have enough information to get the legal documents, for example, a search warrant. At the committee that looks at ethics and privacy, we've often talked about cabinet confidence. And do you believe that access to these documents should be increased? Because currently the answer is a resounding no. It's a no, and it's not a decision that I can make. Even if we had made the request and it had been accepted, I don't know what kind of information would have been distributed. We can make recommendations here, and do you think that we should recommend better access to those cabinet confidences? If you want more transparency, then I think that would come back to what we said about the public's trust and ethics earlier. That would be an improvement. We've seen in other cases that documents were redacted, perhaps overly redacted, and so if we were to recommend having more access to cabinet confidences, you wouldn't be against that. I wouldn't be against what you recommend for transparency's sake. When you look at what happened around SNC-Lavalin, is there anything that you would have done differently? I will ask my colleague to respond. To respond to the question, Mr. Chair, we followed the different steps according to the information that we had. So I'd be speculating. So you would do the same thing. With every investigation, we follow the same steps. We follow the evidence. Thank you, Mr. Villemur.
Thank you very much. I'm going to try to go through this. 2019, you applied for an order in council disclosure that started an interview process with key witnesses. Of the key witnesses, did you directly interview Ms. Honorable Jody Wilson-Raybould?
Yes, we did, Mr. Chair.
And in the course of your questioning, was Jody Wilson-Raybould able to provide you with all the information that you were asking of her in those interviews?
Again, we had to follow the parameters of the waiver and authorization that we obtained.
So in other words, is it safe to say that in that interview with the former AG and Minister of Justice, she would be unable to disclose information pertinent to the foundation of an investigation for potential charges or perhaps documents that would be ordered through, attained to the courts?
That's correct, Mr. Chair.
And so it's logical to say that when the Honorable Jody Wilson-Raybould states, based on what the parameters of the OIC, that there isn't grounds for criminality, it's within those type parameters from which you would have also drawn the same conclusions.
We came with these conclusions based on the parameters for which we operated.
Was there a frustration in not being able to actually get to the heart of the matter?
I would not call it a frustration, Mr. Chair, but of course we always endeavor to obtain as much information as possible so that the information is as complete as possible.
Was there an opinion in that interview that if Honorable Jody Wilson-Raybould was able to say more, she could have said more if those parameters weren't put on it?
Again, Mr. Chair, I would not be in a position to speculate as far as what information could have been provided and if that information would have led to the establishment of the elements of the offense.
Was there anything within that interview that would have given you any kind of credence for requesting an expansion on the OIC to allow you for greater access to personal testimony and documentation?
So to this question, Mr. Chair, I would have to say that of course, we sought an expansion to the original order in council.
And it was denied?
And this, of course, we made the request, and we obtained a waiver and authorization, which were the same parameters as the one in order in council 2019-0105.
So you made a request for an expansion, it was approved, and they gave you the exact same information of the original OIC?
What I should specify, Mr. Chair, is that we did receive a waiver and authorization, not to the parameters that were requested.
Correct.
But we did receive one. So
Which was the same as the original.
Thank you, Mr. Green. Merci,
I share your
Mr.
frustration. Thank you.
Okay, thank you. We're going to go 5-5 and then reset. Monsieur Berthold, pour 5 minutes, s'il vous plaît. Monsieur Vernier, est-ce que tu peux prendre la chaise pour quelques minutes, s'il vous plaît?
Oui, bien sûr.
Oui.
Merci. Merci beaucoup, Monsieur Duhem, Monsieur Pincens, pour votre présence.
Thank you, Monsieur Duhem and Monsieur Pincens. You were interrupted last time because the Liberals didn't want us to shed a light on why the criminal investigation had been stopped on SNC-Lavalin, and they're continuing to do that. It seems clear that the RCMP didn't put in as much effort as the Ethics Commissioner into their investigation. The Ethics Commissioner stated that Justin Trudeau violated Section 9, and you didn't do as much. Mr. Chair, the Ethics Commissioner's parameters and criminal investigation parameters are completely different. I'm going to ask another question. How many hours did you spend on the investigation? I'll ask Mr. Pincens to respond. Mr. Chair, I don't have that information. We're talking about a considerable amount of time. You don't have an answer. How many investigators were allocated? I don't know the exact number, but about 10, under 10. How many people were investigated? We spoke to 4 witnesses, and there were 5 interviews, 4 witnesses. And so you were aware of the list of people who were questioned by the Ethics Commissioner. I just have a few questions. The Ethics Commissioner spoke with Ben Chin, Adair Mekaz from the Prime Minister's Office, Michael Warnick from the Privy Council, Bill Morneau, Finance Minister, Justin Tu from the Finance Department, Katie Telford, Gerald Butts, Neil Bruce of SNC-Lavalin, and Justin Trudeau. Did you interview any of these people? No, we did not, with the list that you had. And so how can you say that you spent as much time and as much energy as the Ethics Commissioner on your investigation to determine that no charges were to be laid if you did not take the time to validate the information? My response in this case, Mr. Chair, is that we followed parameters in interviewing witnesses. We were looking at witnesses who could give us information, if you would allow me, that would allow us to determine the offense. Mr. Pinsins, did you request access to any kind of documents? We received documents from certain witnesses. Were you refused documents during your investigation? Some documents we were not able to examine considering the parameters. Did people say to you, no, you can't have access to this information for your investigation? Yes, for the parameters. Who refused to give you information? It was a witness, the chief of staff, pardon me for using the English terminology, for Miss Wilson-Raybould and Miss Prince. And so they refused to give you information. Shouldn't refuse. I believe that the information was outside of the scope of what was authorized. You talked about fraud and the intention to commit fraud. How could you then conclude that the Prime Minister did not have the intention of committing a crime if you did not even take the time to ask the question to the Prime Minister? In this case, when we're talking about RCMP interviews, we reviewed all of the information in different testimonies, whether it be the Ethics Commissioner or other sources. The strategy was to establish the facts that an offense had been committed. Mr. Pinsins, you know that everybody's going to be looking into an RCMP investigation into the Prime Minister. Brief answer, please. Inaudible. I can say that we have a different mandate from the Ethics Commissioner. We need to follow the criminal code. Thank you very much. Mr. Sorbera, you have 5 minutes.
Thank you, Chair, and welcome, Commissioner Frederica and Michael. It's good to have you here with us today. I am new again to the Ethics Committee and working with my colleagues here, and I've tried to get up to speed on everything that's happened. First off, I just on a different tangent, because I think it's worth pointing out with the RCMP, where I was born and raised in northern British Columbia in a place called Prince Rupert, there is an RCMP detachment, and I do want to give a shout out to all the officers that are sent there from all parts of Canada to northern British Columbia to provide public safety, and I do want to get that on the record because it is the town I was born and raised in and shaped many of my views today. The one question that I think is of very high importance to me, and I'm not a lawyer like some of my colleagues and don't profess to be, is the operational independence of the Royal Canadian Mounted Police. How important is that operational independence? And specifically, when I say that, the responsibility being a member of Parliament is a responsibility, obviously, is to study legislation, but to also act responsible in our statements, in our tweets, in our comments about what our public security organizations do and don't do. So whether it's yourselves or CBSA, RCMP, York Region Police, where I live, Vancouver Police Department, any police department, how important is that operational independence for yourselves?
Mr. Chair, highly important, the operational independence, of course, and I've shared earlier that I've been in a senior position now since 2016, and I can count on probably one hand the number of times I briefed the Prime Minister or the number of times I briefed the Minister for ongoing. So we don't brief on a regular basis on the files that we're doing, even less if a file involves an elected official.
And following up, there's something we learned in as being a member of Parliament. You shouldn't do what you can't do directly and try to do it indirectly. So when you put out a tweet and say the RCMP or some public security organization hasn't interviewed or not interviewed an elected official, you're basically trying to do something indirectly what you're doing directly and trying to direct the police to do in order to do something. And I find that really, really, really scary. I find that frightening. I'm going to almost use, I find that almost Trump-esque in terms of what the other side likes to do and how they like to tweet and comment, because the operational independence of the RCMP is something that we must hold high. The bar is so high because we do live in a democracy, and it is a foundational principle of our democracy. Wouldn't you agree on that, on the operational independence side?
I agree, Mr. Chair.
Okay. And secondly, sir, your organization, your forces, your members obviously investigate and reinvestigate if they need to. If there is new information that is provided to your organization on any file, be it organized crime, terrorist counter, cross-border crime, anything like that. Is that correct, sir?
That's correct. I mentioned that earlier, Mr. Chair.
Okay. And how much time do I have, Chair?
1:42.
Okay, so plenty of time. With regards to the issue at hand, in regards to the laying or not laying of charges, I have understood that in October of 23rd of October 2023, you had mentioned to reporters that you were very comfortable with the RCMP's decision not to pursue any further investigation or criminal charges into the SNC-Lavalin affair. I take it, Commissioner, you would make those comments, you would make that statement publicly with a high degree of comfort.
Yes, I did make that statement, as I made the statement here in front of the committee members.
Okay. And in addition, Commissioner, in terms of the resources that you have at your disposal, would you say those resources are robust to pursue investigations that you feel, or that your folks that report into you are able to do so? Would you feel you have sufficient resources to conduct investigations, whether it's an investigation looking at public officials, whether it's an investigation looking at organized crime, terrorism, or so forth?
Yeah, like any file, sometimes the file takes a different direction where it requires to add additional resources, so we prioritize the work that needs to be done and assign additional resources to a specific file.
Okay. And my final sort of comment, and going on this tangent, is as an elected public official, you have certain responsibilities, Commissioner, and your Commissioner is to be, your responsibility is to be responsible in your comments, especially when it comes to matters where there may be ongoing investigations, or there were ongoing investigations. And to play this sort of, not even Monday morning quarterback, because I think it's a lot worse than that. I think when you are questioning the independence, and even I would say the integrity of our police forces and the brave men and women who put the RCMP uniform on and go to the depot, I think it's Saskatchewan, if I'm not mistaken, Regina, to get the training and go forth.
Mr. Sabera.
It's very, very important that we maintain that operational independence.
You're 30 seconds, 30 seconds over.
So with that, sir, again, I'd like you to stress the importance of the operational independence. Thank you.
Sorry, Mr. Sabera.
No,
1
thank
minute
you,
and 41 seconds turned into over 2 minutes. So, okay. I am going to, that concludes our first round. We're going to reset the clock. I'm going to ask our witnesses today, Mr. Duhaime, Mr. Payne, are you good to continue, or would you like a break for a couple of minutes? I'm good. Okay. Okay. Members of the committee, you're fine to continue? Okay. So we're going to start our second 6-minute rounds with Mr. Cooper for 6. Go ahead.
Thank you, Mr. Chair. Thank you to the witnesses. A part of the RCMP's examination to determine whether the Prime Minister violated Section 139, Sub 2 of Criminal Code by committing obstruction of justice, correct? That was part of the RCMP's examination.
That's correct, Mr. Chair.
And paragraph 19 of the RCMP investigation report states that the strongest theory towards an offense of obstruction of justice was that the Prime Minister shuffled Jody Wilson-Raybould out of the position of Attorney General so that a new Attorney General would make a different decision regarding the prosecution of SNC-Lavalin, correct?
That's correct, Mr. Chair.
And it's fair to say that the RCMP did not have access to all material evidence surrounding Ms. Wilson-Raybould being shuffled out as Attorney General, correct?
That's correct, Mr. Chair.
And so, just to clarify then, or emphasize, the RCMP did not have access to all material evidence on the strongest theory surrounding the Prime Minister's potential criminality involving obstruction of justice, correct?
That's correct, Mr. Chair.
And the reason the RCMP did not have access to that material evidence on what was central to determining whether the Prime Minister broke the law was because of the parameters of the scope of the Order of Council with respect to the waiver of cabinet confidentiality, correct?
That's correct, Mr. Chair. The parameters did not allow us to fully look into this one. However, I should just add...
Thank you for that. You answered it. The parameters did not allow you to get that evidence. Now, there is one person who had the authority to expand the parameters of that Order in Council, and that is the Prime Minister himself, correct?
I would have to say, Mr. Chair, I'm not exactly sure of the exact process of where the Prime Minister would be involved in such a decision. However, I do believe the decision has to be made within the somewhere within the government.
I would submit the decision would have to be made by the Prime Minister, but the RCMP went and requested an expansion of the scope to obtain that evidence, to follow that evidence, correct?
Before we proceeded with the assessment, yes, we did make a request for an expansion to the parameters.
I would just add, Mr. Cooper, it was not to follow the evidence, it's to glean additional information. That could be evidence.
Correct. And that request was turned down on August 30th, 2019.
I would have to say, Mr. Chair, that the request for the expansion was not allowed.
It was turned down, and it was turned down by the PCO, the Prime Minister's Department, correct?
Mr. Chair, we did receive a letter from the Department of Justice. I could not remember exactly, specifically, if this came from the...
Well, it was from the PCO, and that's in the RCMP's investigation report. And would it be fair to say that the refusal by the Prime Minister's personal department, the PCO, to expand the scope of the Order in Council significantly impeded the full investigation into the Prime Minister's potential obstruction of justice?
It limited our capability of pursuing a full investigation.
And it would have limited it in a fairly significant way. Because after all, we're talking about going to the heart of the matter of obstruction.
And again, I don't know what additional, not knowing what additional information is out there, it's hard for me to speculate that there's a Pandora box out there which is full of information, so it's hard for us without speculating.
Well, let the record show that the Prime Minister's Department, the PCO, obstructed the RCMP investigation into the Prime Minister's potential obstruction of justice. Are you aware of any other Canadian who can single-handedly block the RCMP from investigating his own criminality in such an effective way as the Prime Minister?
Good question.
Fantastic. I wouldn't use the term, Mr. President, I wouldn't use the term block. The RCMP is, when it runs an investigation, it operates within the parameters and the regulations that we're allowed to. And we see international security investigation as well, where there's some information that we don't have access to, we can't use into an investigation. So it's the parameters. It's the parameters that we are.
I think the answer to that question is there is no one who has such powers. And was any explanation provided by the Prime Minister's personal department why there was this refusal to expand the scope of the Order in Council?
Again, Mr. Chair, as far as for a response on this one, of course, it was indicated, of course, the importance, of course, of these privileges that do exist. They are there for a reason, and again, as the Commissioner mentioned, we do have to operate within these parameters.
It would seem to me to be part of a pattern of a cover-up.
That's right.
That's what it would seem to me to be. How can the Prime Minister be subject to the rule of law, like every other Canadian, if his personal department can shield him from an RCMP criminal investigation?
Absolutely. So, Mr. Chair, I'll let individuals draw their own conclusion. What I come back to is we operate within a set of regulations and parameters that, unfortunately, we made the effort to go and get additional information, and it was refused.
Thank you, Commissioner.
A two-tier
Thank
system
you.
of justice, I would say.
Thank you, Mr. Cooper.
I was thinking just that.
Mr. Baines, you have 6 minutes. Go ahead, please.
Thank you, Mr. Chair.
Can we just have some decorum, please?
I believe it's my time.
And Mr. Baines, go ahead.
Thank you, Mr. Chair, and thank you, Commissioner and Sergeant Pensons, for joining us today. And I also, like Mr. Sabara, have RCMP in my city, Richmond, British Columbia, so I want to give them a shout out as well, and thank you for your service and the work you do. I want to go into the line of, I think you mentioned earlier about the Ethics Commissioner. Well, you said nobody is above the law. The threshold wasn't warranted. The production order wasn't warranted to go forward. And the Ethics Commissioner had access to more information than the RCMP. Can you maybe talk a little bit more about, we heard from my colleague from across who talked about all of the different interviews that the Ethics Commissioner went through. So clearly the Ethics Commissioner's office had more information. And is it the duty of the Ethics Commissioner to provide documents if they find something of a criminal nature that's taking place?
So,
What's your understanding of that? Can you talk a little bit about that and what your relationship is with the Ethics Commissioner?
Of course, yes. So, Mr. Chair, of course, I'm not going to call myself an expert on the matters of the Conflict of Interest Act. With the Commissioner of that department is doing an exemplary job to try to pursue these examinations. So as far as my understanding of the situation in relation to the Ethics Commissioner is pursuant to the Conflict of Interest Act, there are some compulsory powers that's available to the Ethics Commissioner to really go and conduct a very fulsome examination of the matter. Of course, with these compulsory powers, which are to summons witnesses or to obtain documentary evidence, which can be summoned. At the same time, with these additional powers, does come confidentiality clause that's set in place to allow for the Commissioner of Ethics to conduct an examination, come to a conclusion on a balance of probabilities in relation to a conduct of an elected official or a public office holder.
So, if I may, Mr. Chair, just to add, the Commissioner has a duty to suspend his examination if he comes across any criminal wrongdoing, if you wish, which was not the case in this case.
So he would suspend his role and then pass it along to...
My understanding of the Conflict of Interest Act, and it's in the investigative report that's been provided, there is a duty there that if there's any criminal wrongdoing, he's to suspend his activities, and normally you'd think it's reported to us for follow-up.
So it's safe to say that the Ethics Commissioner in this case interviewed all of those people that Monsieur Berthold listed and came to a conclusion. If there was something of some wrongdoing or criminality there, he would have to suspend at that point and then pass along that information to the RCMP? Is that safe to say?
My understanding is correct, yeah.
Okay, so if you, so, and I just wanted to clarify one more thing. I think I wasn't sure if we got the answer on. The only reason that the final letters of the case, your investigation concluding to Ms. Wilson-Raybould and Mr. Scheer, it was only due to, it was an administrative, is that administrative reason, just because there was a turnover and it was just information that needed to get out, it just didn't get out earlier?
No, and yes, and that's what I said. It's internal in the sense that there's several key players that moved along. The report was concluded in spring of 2021, and that's on us. And we put measures in place to make sure that there's a monthly reporting on sensitive files of this nature.
Mr. Hummer? Okay. So you talked about the number of interviews you concluded. And throughout the investigation, we know that you've indicated that you're very comfortable at this point. And would you still say that after reviewing all of the documents that you got from the ethics commissioner, what did the ethics commissioner pass along? Did they?
So, Mr. Chair, to answer this question, actually, we reviewed the report from the ethics commissioner, again, because of confidentiality clauses which are within the Conflict of Interest Act. We were not privy to the extent or the material evidence that the ethics commissioner reviewed. Of course, we have to rely on the excerpt of his report.
So, just a hypothetical, like if in the case that, so again, the RCMP is independent. If I was to say, I need you to look into this investigation of anything, please investigate this matter, some matter, you just don't take it for somebody's word. You don't take orders from politicians, nobody is above the law. You would have to look at the evidence and then you would move forward with any case, correct?
Very short response, please.
I'd say, Chair, Mr. Chair, correct, in the sense that we need, most times, we need someone who's going to lay a complaint, and we can investigate. Just a sidebar saying, investigate this, that doesn't cut it.
Okay, thank you.
Thank you, Mr. Baines. Monsieur Vermeer, pour 6 minutes, s'il vous plaît.
Merci, Monsieur le Président.
Thank you, Mr. Chair. I have a few questions for you, but I'll come back to something. My colleague's question surprised me. He talked about a list of people that had been interviewed by the ethics commissioner, and you interviewed four people. Since when does the RCMP consult somebody else's investigation to find out whether or not they need to carry out their own? Microphone, please. Apologies, Mr. Chair. We use the information that's available to us. We assess the information to see whether or not it has value. But you didn't interview the Prime Minister. I'm not a police officer, but you had information at your disposal, and that was enough to not go further. So in the 4 people that you spoke to, you didn't speak to the main witnesses. I would say quite the opposite, actually. The people that we interviewed were key witnesses to determine the elements of this offense. This helps us decide what to do. In following your usual protocols, were there any issues, without using the word frustrations, but there were perhaps things that didn't go as well as you'd hoped? I would have thought that a person at the heart of an issue would have been interviewed. To add to your question, we tried to determine the facts. We'll have the different steps, and we'll go through key witnesses that could give us information. Is the Prime Minister not a key witness? We need to look at the situation at the time and the information that we had. The Ethics Commissioner has a purview to look into the ethics of a situation. We look at the criminal aspect of an investigation. We won't move forward with other steps if there was no criminal offense. The Commissioner stated that he will assess whether or not it was compliant to the ethics code. For ethics matters, it could be an indication of criminal activities, but not in all situations. Of course, but what the Commissioner looked at is not what you looked at. You looked at 2 different things. He looked at compliance to the ethics code and found that it was non-compliant. But for you, that non-compliance didn't mean an automatic investigation. In a usual investigation, in a theft, you speak to the suspects, do you not? And you collect the information that you find sufficient? Well, it starts with a complaint, and then we follow the information, we look at the evidence, and then either we lay charges or we try to get access to a warrant. Did the Commissioner's investigation cause you any issues? I would say no. There are two different mandates here. There's the ethics and the criminal aspect. And the thresholds are different. As legislators, what could we do to help you maintain or regain trust in the RCMP? What can we do? Well, the national surveys showed that trust towards the RCMP is higher than before. In carrying out an investigation like this one, the fact that we have parameters to respect is important. We want to be transparent. And if you want to have better parameters, that's not up to me to decide. We've talked about cabinet confidences here, and we're a bit uncomfortable with it. We get the impression that what is considered a cabinet confidence can be just about anything, and it's not used properly. The current government used it quite liberally. And so we look at assessing the current state of cabinet confidences. And you mentioned earlier that more transparency would be helpful. It is the interpretation of a cabinet confidence. What's your interpretation? I will not give my comments, Mr. Chair. Thank you. Not answering is an answer, by the way.
Minutes, go ahead, please.
Thank you very much. And in a tangential way, I'm going to pick up where my good friend from the block left off. I'd referred to the duty of candor. Jurisprudence in parliamentary proceedings would suggest that committees, standing committees, constituted by the House of Commons, are the grand inquest of the nation and have the power to send for documents, people, and any information pertaining to their studies. I want to get back to the timelines, because it is an important thing for me, a discovery, to ensure the public that there was nothing nefarious happening with the allegations that are being branded about, both at this committee and out in the public. So I want to get very clear, Mr. Commissioner, and I need for you to provide me with a clear answer. When the decision was made not to pursue charges, precisely when was that?
There was no further investigation activities as of spring 2021. As to the exact time and date that I read the report as Deputy Commissioner at the time, I wouldn't be able to. I don't recall the exact time that was submitted and when I read it. So.
And when you read that, would you have reported that up to your superior, the Commissioner at the time, Brenda Lucky?
I would have gone through it, have a discussion with the direct report who's responsible for the program, and then discuss with the Commissioner.
Would all of the decisions along the way would have they been reported up to the Commissioner at the time?
There would be a fulsome decision if we had to lay charges or not lay charges. There'd be a fulsome debrief or brief, I should say, with the Commissioner as to the reasons why.
And in terms of specificity, we talked about phases. I want to get crystal clear for a moment, and I want to suggest to you that this committee, in my opinion, would have powers to send for documents, including primary documents that would be within the RCMP related to this particular case. So rather than have to move a motion to demand for documents, I just hope that you could put on the record today, when exactly, you said spring of 2021, when was it made public that the investigation had ceased?
Honorable Madam Wilson-Raybould was informed January 2023. I'm not quite sure if we went out publicly, Fred. Not quite sure if we went out publicly. Following the discussion we had with Madam Wilson-Raybould, we did inform Mr. Scheer, who had a written complaint into the commissioner, and we responded to that letter. So the exact date it went public, I'm not sure.
Well, I would suggest to you that given that there's a 2-year span, or at least a 1.5-year span, between when the decision was made and when it was ultimately made public, I would put to you that is highly problematic given the timing of, the politics at that time. So the question I put to you is, why did it take a 1.5 years from the decision to end the investigation to the time that it was made public?
So I've shared it earlier, Mr. President. It's an internal matter, which is addressed. It was hard for me it's hard to think that this would be suspended when no one in government was briefed on this file. Until I don't even brief the Prime Minister or the Minister even after we informed Mrs. Wilson-Raybould. So it's entirely on us, the delays of a 1.5 years. It's
So
got
who
nothing to
made
do
that
with,
decision?
It was a combination of change in reporting structure, that the reports were not getting up and the proper follow-up was not made. So it was done inadvertently.
I would put to you, sir, given the seriousness of this, given the highest level of leadership in our country, that an inadvertent omission for a 1.5 years, with these allegations floating out there about the Prime Minister, the kind of lack of trust and cynicism that the hyper-partisanship would bring in this environment, it warrants more than a response of like an inadvertent change in command. And so I'm going to go back to you because ultimately now you are the leader you are the commissioner of the RCMP. So I'm going to put to you how you take responsibility for the fact that given the highly politically explosive nature of this, it was literally a campaign question, I believe, in 2019, and is certainly continues to this day, so many years later, to be a political question. How does that happen?
I don't have an explanation of how this happened. Honestly, there's a combination of factors. But as I said, we put measures in place from a sensitive file of this nature. From now on, there's monthly reporting provided to the commissioner to ensure that we don't miss anything.
I wanted to be very clear, because this committee has the power to send for documents. I need this just to be on the record. This is not a personal accusation to you or your character. If I were to move a motion today asking for the timelines and the internal documents related to the decision-making, and it came back to that committee, is it your testimony that that would be 100% congruent, that somehow it just fell off of somebody's desk somewhere, and that there was no internal communication based on the timing of the decision to ultimately go public on this?
I'd be more than happy to provide the committee here any information on the timelines. And like I said, to the best of my recollection, as the Deputy Commissioner, there's some change at the senior level staff, just underneath that were reporting into me, that made this, we incurred delays. And I'm sure there's other factors as to why we had delays.
So with that, and giving him the courtesy and the respect due accord to a commissioner of the RCMP, I will not move a motion for that, but I do want to go on the record, sir, Mr. Chair, that there has been an offer to submit internal emails and communications regarding the timelines of the gap between when the decision was made to end the investigation and when it was made public. And I just want to, through you, make sure that that's what we understand collectively as a committee here without having to move a motion.
That is my understanding.
And that is your... Yep. Okay, thank you.
Thank you, Mr. Green. Thank you, Mr. Duhame. That concludes our first round of the second hour. We're going to go to 5-minute rounds, and we're going to start with Mr. Brock. Mr. Brock for 5 minutes. Go ahead.
Thank you, Chair. Gentlemen, pursuant to the ATIP received by Democracy Watch, I understand that literally within hours of Jody Wilson-Raybould's testimony at the Justice Committee, you were engaging in discussions with a local Crown attorney. Is that correct?
I would have said, Mr. Chair, following the review of the testimony, yes, there was some consultation.
There was a telephone call. There was actually a meeting with the Crown attorney the very next day. Is that your recollection?
It was shortly after. Sorry, Mr. Chair, I cannot remember exactly the day, but shortly after, yes,
and
that's correct.
Did you get any sense from the Crown attorney during those initial discussions, those initial days, that there was a reluctance from the Crown Prosecution Service not to give you advice with respect to charging Justin Trudeau?
I would not go into the full detail of what discussion took place between us and the Crown in this regard, as far as for this. But yes, there was some discussion that took place shortly after. That's correct.
We know that every charge under the criminal code carries with it two elements: the actus reus, the mens rea. The act itself, the intent, correct?
That's correct.
And are you familiar with the leading authority on obstruction of justice, Regina versus Beaudre from the Supreme Court of Canada?
I would say right now, I wouldn't know the full details, Mr.
I'm
Chair.
going to read out a couple of components. The actus reus of the offense of obstructing justice is that the act has the tendency to defeat or obstruct the course of justice. The mens rea is a specific, deliberate intent to do the act which will result in an obstruction of justice. Success is not necessary. The offense is made out even if the accused fails to succeed or fails to complete the attempt to commit the offense. Pursuant to another decision, Regina versus Watson from the Ontario Superior Court, it is no defense that the actions were an error in judgment or a mistake. With the evidence that you did receive, which largely consisted of the Ethics Committee report, the testimony of Jody Wilson-Raybould, was there an impediment of the actus reus or the mens rea to obstruction of justice?
I would have to say, Mr. Chair, when we conducted the review, I would have to say the mens rea portion of it was part of the main focus of our review.
Thank you. I left off in my first round, which was essentially talking about the evidence that we heard from Jody Wilson-Raybould, that this wasn't a one-off, that over the course of 4 months, no fewer than 11 different officials from the Prime Minister and down in a series of meetings, memos, and telephone conversations attempted by means of varying degrees of subtlety to change the AG's mind. Explicit political considerations were raised, the impact of SNC-Lavalin's conviction, job loss, and company relocation, which was later proved to be a lie, and upcoming elections, both provincially and federal. This at all times was Justin Trudeau's problems. We also have recorded evidence, not just a he said, she said, recorded evidence between Jody Wilson-Raybould and the Clerk of the Privy Council. I'm quoting here from Michael Warnock. The Prime Minister is quite determined, quite firm on this. He said that 4 times. Wants to know why the DPA route is not being used. He's going to find a way to get it done one way or another. He's in that kind of mood. This is really important to him. If that doesn't cry out for a specific intent, I don't know what does. What do you say about that?
What I have to say, Mr. Chair, is when we looked at this specific, and of course I'm referring to the quotes that were just mentioned here, but of course in the assessment we did assess these comments were made. But again, we had to take a more global approach when we looked at all the comments that were made. So of course, our determination vis-à-vis the mens rea portion is based not only on some of the comments, but on the totality of the evidence, the totality of the statements that were made.
And the totality is the Prime Minister made this his personal mission to interfere in the criminal prosecution for his own political needs and the needs of SNC-Lavalin. Do you agree or disagree with that statement?
Mr. Chair, I would say that the assessment that we've conducted, again, our conclusions were that there was insufficient evidence to substantiate an offense.
Do you understand why Canadians feel there's a 2-level tier justice here in Canada, that the Prime Minister is immune from prosecution because he can hide behind cabinet confidences? He can commit a litany of criminal offenses and just say, sorry, cabinet confidence, I'm not going to allow the RCMP to investigate. Do you understand their concerns, sir? Do you understand Canadians' concerns?
If you quick response, please.
Yes, Mr. Chair. As far as for this, and we're talking about like ethics and criminality here, which sometimes seems to be intertwined. But again, as I indicated earlier, we have to follow the parameters as laid out in the criminal code.
Thank you, Mr. Pensas. Mr. Brock, Mr. Housefather for 5. Go ahead.
Thank you, Mr. Chair. My colleagues, Mr. Cooper and Mr. Brock, are both excellent attorneys, and they covered some matters that I would like to revisit. Mr. Cooper was trying to make the point that the Prime Minister himself was somehow involved in the decision by the Privy Council office to not allow the RCMP request for certain documents that you had asked for witnesses. I refer back to the assessment report, paragraph 211. It says, on June 13, 2009, Mr. Sugar, who was then the newly appointed clerk of the Privy Council, declined the Commissioner's request for access to all Cabinet confidences in respect of the examination. As reported by Mr. Trudeau's legal counsel, the decision on whether to expand the waiver was made by the PCO without the involvement of the Prime Minister or his office. Beside the limitation, the Commissioner felt there was insufficient information available to reach a conclusion on the matter. Do you have any reason to dispute what you've declared in Section 219, that the decision was made by the Privy Council office without the involvement of the Prime Minister or his office?
Mr. Chair, we have no information as to who partake into the decision-making process.
Perfect. So nobody else would have that knowledge other than the people involved, and to your best extent, when they're saying this, that would be correct?
That would be correct, Mr. Chair.
Thank you so much. And we're talking now about this double standard. Here, you were not asking a court to require the production of documents. You were asking for voluntary disclosure of documents, correct?
That's correct.
Does every investigation, because now we're talking about double standards, does every investigation that you have witnesses that offer documents without requirements for like that you're asking them to deliver, and they always do it, and this is different?
I would have to say, Mr. Chair, there are situations where witnesses do provide information, but
it's not always happening. There's many times where people decline to provide documents.
That's correct, Mr. Chair.
And in the event that the RCMP had determined that it wished to proceed down the road of an investigation of that disclosure of further documents, you did have enough evidence to substantiate, you could have gone to court to seek the production of these additional documents as well, correct?
That's correct, Mr. Chair.
Okay, thank you. Now coming to Mr. Brock's comments related to the analysis. In Section 240 and following of the assessment report, you've done a very detailed assessment of all of the evidence holistically and come to the conclusion that there was insufficient evidence to go forward with further production attempts to produce documents or a criminal prosecution, correct?
That's correct, Mr. Chair.
And you took into account other elements than the one Mr. Brock offered. For example, that nobody ever told Ms. Wilson-Raybould there was anything other than her decision, correct? As to whether or not to do the deferred prosecution agreement, or as we call it, a remediation agreement, correct?
From my recollection, that's correct, Mr. Chair.
Thank you so much. And again, now to tie this up again, my colleague Mr. Green also made some interesting and very excellent points. Can I ask a question? Normally, the RCMP would not disclose that you were doing an investigation of someone, nor would you then confirm that you'd closed that investigation if the decision was not to charge them, correct?
We don't normally go out after an investigation to say that there's charges or no charges until the documents are presented in court, and then it's in the public domain. Then we'll comment. But
so you normally So normally you would not disclose to the Canadian public either A, this person is being investigated, and two, that you closed the investigation and are not proceeding on it, correct?
Correct.
So this was outside of your normal procedures. You wouldn't normally have these issues because normally you wouldn't be doing any of this, correct?
Yep.
Okay, I look forward to seeing the documents that you're going to provide based on Mr. Green's questions. Then finally, there's been a lot of allegations. Again, can we confirm again that the Prime Minister was not necessarily the one person of interest in this investigation?
No, I think when you look at the report, there's people from PMO's office, there's people from the Justice Department, and others that were interviewed.
So the idea that this one person was the center of everything, and that this one person was the person you were looking at, and that you had decided through political pressure to close that investigation is false, correct?
We had no political pressure in this file.
Thank you. I imagine my time is up. Thank you, Mr. Chair.
Okay, thank you, Mr. Housefather. And just while it's top of mind, because Mr. Housefather brought it up and so did Mr. Green, those timelines that have been are you able to provide those by Friday, Commissioner? Or do you need a little more time?
I would need more time
Okay,
because
so can we-
the timelines, rough timelines, yes, but then we're referring to emails and correspondence. Let me go back to my team, and then I'll be more than happy to follow up Secretariat to say how long it's going to take us.
Okay, I would
This
appreciate
is like
that.
a mini
because-
ATIP request that I have to ask our team how much
Right.
information's there, so.
Thank you, Commissioner, because we do want to make sure that we have that information as soon as reasonably practicable, okay? Thank you. Monsieur Villemure, pour 2 minutes et demie, s'il vous plaît.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Mr. Commissioner, what is your understanding of the mandate of the Ethics Commissioner? My understanding is that the Commissioner is responsible for ethics, behavior. I think it covers all elected officials, but I'm not fully aware of the Commissioner's entire mandate. Could there be confusion between one and another's mandate if it's less well known? You're referring to the criminal versus ethics mandates? I believe that the parameters are different. For investigations, we have the criminal code and what needs to be proven, and that's different from the ethical side of things. Mr. Chair, I would like to table a motion to invite the Ethics Commissioner. I don't want to take the committee's time. I'll do it at the end, but I just wanted to let you know that I will be doing that to clear up any gray area. Thank you, Mr. Villemure. I know I don't have a lot of time left. You're looking at this retrospectively. I know you won't say that you would have done things differently, but have you learned anything through this process? I think that, honestly, the challenge that we have in investigating in such limited parameters without having all the information brings up the matter of transparency. If you don't have all the information, it's difficult to say that justice was served. I don't agree with that, but we don't know what other information there was. Perhaps there was more information or less information, but we can't speculate. That's what's interesting. It could condemn or not. I agree. I would prefer that we could confirm everything, but anyway, thank you, Mr. Chair. Thank you, Mr. Villemure.
Thank you very much. I want to give you the opportunity with the ability to have hindsight, given your participation and now your ascension to the Commissioner of the RCMP. Are there any lessons that could be drawn or recommendations that you'd like to provide this committee regarding the SNC-Lavalin affair? For instance, if the same situation were to come up again, would you take the same approach? If so, why? And if not, what would you do differently?
I'll let Mr. Pain's refer about the same approach, but I go back to Monsieur Villemure's question with regards to transparency. That's something that is not in my ballpark, but again, the parameters in which we had to work with were challenging, but understanding that those are parameters we have to work with. If there's a common agreement where we have to expand
I want to go to that. Do you believe the RCMP should have unrestricted access to cabinet confidence as a part of its investigations?
It could facilitate some of the investigation, but again, I'm not familiar with.
I'll put it another way.
Yeah.
You had mentioned that nobody is above the law.
I did say that.
Does cabinet confidence put a shield between the cabinet, the PMO, and the law when you're dealing with investigations?
Well, it does, because we don't have access to all the information.
So do you believe that the RCMP should have access to the cabinet information when investigations are happening to ensure that nobody is above the law in Canada?
So I'll go back. Cabinet confidence is there for a reason. And I think the interpretation of cabinet confidence, which we had a discussion earlier, sometimes differ from one person to another. And I think the reason why there's a reason for that. And I'm not an expert to explain what the reason is.
Sure. Often it's national security, it'd be my opinion that, to your point, When the client is both the solicitor and the client, it becomes very murky, and I think that those need to be separated as per Honorable Jody Wilson-Raybell's recommendations and many other legal recommendations of the same. But I digress. In light of the Trudeau II report, do you believe that amendments to the Conflict of Interest Act or other legislation or policies governing the conduct of public office holders are needed to prevent the allegation or the alleged actions by the Prime Minister Trudeau in the report going forward?
I'm not aware of the whole Conflict of Interest Act, so it would be inappropriate for me to comment on it if there needs any changes or whatnot.
Do you believe that the commissioner has the ability to determine what is criminality in order to make reference or referrals to the RCMP for investigation?
Quick response, please.
I would assume that because it's in the act that he's to stop the investigation. If there's a criminal wrongdoing, I would imagine that the person who's the commissioner has that understanding of what's criminal to refer it.
Thank you.
Okay, thank you, Mr. Green. Before we go to Mr. Barrett, we're going to go 5-5. I am going to extend the meeting by about 15 minutes. We have the resources to do an additional 5-5 and then 2.5 past that point. Mr. Barrett, go ahead, please, for 5 minutes, and then Ms. Khalid followed next. Go ahead.
An official inquiry of Ministry number Q1649 concerning communications and pressure by government on the SNC-Lavalin affair concerning the date June 19th, 2023 revealed a call from a Trudeau minister who was not then the public safety minister, but he is now, and the RCMP described the call as, quote, seeking to speak to the deputy before question period regarding a media story about an RCMP investigation that was A-tipped, end quote. So do all ministers have a hotline to the Deputy of Specialized Policing Services for updates on criminal investigations into their government?
I'm not aware of the incident that you're referring to. And as I said, this is the Deputy of Special Police Services. I'm not aware of that call, and like I said, I brief up.
Okay.
And sometimes there might be clarity if there's an article in the media that comes out with regards to one investigation. Sometimes the minister will reach out for asking clarity.
Sure. Not the Minister of Public Safety reaching out seems highly suspicious. I don't have the number for the Deputy of Specialized Policing Services, and I don't think they'd be interested in taking my call. And so I wonder why the Prime Minister's fixer and childhood babysitter is able to get that kind of access. Are you investigating any contractors or subcontractors who worked on the ArriveCAN app?
So we did receive a complaint referring to inappropriate contract or inappropriate allegations
of misconduct.
And with that, and that was not related to ArriveCAN, and now with the ArriveCAN, we've blended them both into one investigation.
So you're investigating ArriveCAN?
Yeah. Well, not ArriveCAN itself. We're investigating the totality.
The totality.
Yeah.
Okay. Last week at committee, government officials said they're sufficiently suspicious of wrongdoing in the case, and they're gathering documents. So the RCMP is doing the same, is sufficiently suspicious and is investigating. I just need to be clear on this.
Well, Fred?
Sorry, Mr. Chair, just to be clear, which investigation are we talking about?
I'd love a list, but specifically ArriveCAN.
So on the matter of the ArriveCAN, of course, we did receive information on it. We are reviewing the Auditor General's report, and of course, we'll take action as required.
So the AG said that a production order would be needed to get her full files. Have you received? Are you in receipt of all of the AG's files on ArriveCAN?
Again, I would. As far as for the information that the Auditor General has mentioned, as far as for the RCMP requiring a form of judicial authorization to obtain the documentation, of course, this is a step that we'll need to assess to determine.
Have you taken that step? Have you requested the information? Have you undertook that process?
I would have to say, Mr. Chair, right now, because we're in the process of obtaining that information, I would reluctant into speaking to whatever steps the RCMP is taking in relation to this matter or any other matters.
Okay, so you're not able to say because it's an ongoing, it's a developing situation?
Again, Mr. Chair, I would have to say that, yes, we process in each of these cases, we process step by step. We conduct the same level of assessment, and we determine, again, our goal is not to replace the role of the Auditor General or any other bodies.
Sure.
Our role is really to focus on criminal activities, and that's exactly what we're doing in this or other cases.
You know, the procurement ombudsman reported that 70% of resources were bait and switched in the ArriveCAN contracting. We heard testimony of Christian Firth from GC Strategies forging documents, specifically resumes, in order to win government bids. These are very serious things. We've heard that. We've heard this now in the reports of independent officers of Parliament. Allegations of fraud, forgery, threats, intimidation, destruction of evidence, bribery, and extortion. All of these things have been brought to light in this ArriveCAN scandal, and so the question of what's in the public interest, and we've heard today concerns about Canadians having confidence in their institutions. And, with my questions about the Aga Khan issue, it seemed like it stopped short of investigating up to the Prime Minister. With the SNC-Lavalin scandal, it stopped short of investigating the Prime Minister. And my questions today are just to make sure that we're not stopping short of getting all the answers that Canadians need. And I'm just wondering if you have anything more to say with the totality of what you've heard on the Arrive scam. Is there an investigation?
So if I, Mr. Chair, and I confirm that there is an investigation, and we're not going to comment because it's ongoing.
Thank you.
Perfect. Thank you, sir. Ms. Khalid, 5 minutes. Go ahead.
Thank you very much, Chair, and thank you again to the witnesses. I had the opportunity to serve on NSI COP for a little bit, where I really got to have those candid conversations about how the RCMP operates, and appreciated that candid nature of those conversations that we were able to have, and come to constructive conclusions and recommendations and findings as to how we can improve the system better. So I really appreciate, Commissioner, what you had to say about cabinet confidences. Can you perhaps expand a little bit on how those cabinet confidences and that ability to make decisions impacts the work that you do as an independent organization?
Well, Mr. Chair, is what we're living right now. There's no doubt that there is a reason why there's cabinet confidence. As to what extent. And again, we talked about full transparency when we're running investigations, but we also talked about the parameters in which we can operate in, and the regulations are made in such a way that here's the information that's available, and there's a process in place to request additional information, which was refused to us.
Thank you. Now, I realize that we're trying to get to better ways forward, which is why I really appreciated Mr. Green's questions about what's next and how can we prevent issues like this arising. And, my colleagues have brought up ArriveCAN, et cetera. How does political, I'll give you an example. The leader of the Conservative Party sent you a letter demanding that you investigate ArriveCAN. How does that impact your independence? And are you going to be responding to that letter?
Yeah, we'll be responding to the letter. It's a complaint that we received that we're investigating. Take apart the position of the individual. It's a complaint we receive, and we were already looking at the initial complaint that came in, and we'll be investigating.
And, just given the nature of what's been happening in the media and the questions that we've been asked today, do either of you feel that it's appropriate for the leader of the opposition or for other political officials to attempt to interfere with the RCMP's independent work in investigations like this?
I would have to say, Mr. Chair, I would have to say that we always welcome any types of information, either being from anyone and in relation to a matter. Of course, we'll assess that information and we'll take whatever step is necessary based on our assessment and or investigation of the matter.
So, and this is my last question, Chair. I've seen allegations of the RCMP being at the beck and call of Prime Minister Justin Trudeau. Is that true?
Like I said, I haven't briefed the Prime Minister maybe on a couple files since I've been in a senior position, but we're not. The RCMP is not politically driven. We're independent. The fact is that the leader of the opposition can write a letter to ask for an investigation that we're doing it, demonstrate that we're not politically driven.
Thank you. And I'll take this last opportunity to thank you for all of your work and to thank all of the women and men in the RCMP for the excellent work they do in our communities. Thank you.
Thank you, Ms. Khalid. Monsieur Villemure, pour 2 minutes et demie, s'il vous plaît.
Mr. Villemure for 2.5 minutes. Thank you, Mr. Chairman. I'd like to take the most advantage of the SICAD. According to my colleague, Mr. Green, he was saying that with cabinet confidences, and this is an aspect that interests me a lot, that there's a kind of a screen between the Prime Minister and the RCMP in that case. And well, at least it seems to have created that. Now, changing cabinet secrets rather, or confidences is not something that's easy to do, but we're not lawyers. Nevertheless, what I'd like to know from you is, given the changes that have been made to cabinet confidences, which is a very significant thing, and given the needs of the RCMP, when you try to balance the two, do you feel that we should move in that direction, that it would be worth it, or that you think that it's been done once and that we'll just move away from that? Well, Mr. Chairman, I think you have to understand, first of all, why cabinet conferences came into effect and see how it might be applied or changed, and if it's up to us to do so. I mean, you know that, yes. But in your opinion, as a member of the RCMP, did you often have to deal with cabinet confidences, and if so, did you feel that the same parameters were applied, or was it narrower? Within the context of the investigation, no, that's not been my experience. Well, with certain investigations, cabinet conferences have been invoked, yes. So, in some cases, yes, and in some cases, no? That's right. Well, can you say why there weren't any invoked in this case? Well, once again, we can't speculate as to the situation. Well, did you ask for an exemption? Well, no, not in this case, no. It was information that was given to us. So if you didn't ask for it, you wouldn't have gotten it in any case. But thank you in any case for your comments. It will allow me to think further about this. Thank you, Mr. Villemure. Mr. Green.
Thank you very much. And I'm going to do something that maybe I don't do often enough, which is provide the benefit of the doubt to policing institutions and to yourself in the RCMP, because it's pretty clear that under these circumstances, there's allegations of political interference. Under other circumstances, there could be the potential, and I'm just playing this out as a hypothetical, where there could be allegations of the RCMP initiating investigations on politicians that could also be considered political interference from the other side, from an oppositional side. And so what I want to offer you today is the opportunity just to reflect on the fact that, as you've testified, the commissioner had access to more information that you had. I think that that's a hard thing, I'll just put on the record, for Canadians to be able to digest, to look at it, for journalists to be able to digest the fact that the commissioner has more access than the RCMP on this matter. And so you may or may not recall, but it was our part of the NDP who had called for the federal government to launch a public inquiry. And I know that there's lots of conversations around the cost of inquiries and the powers, and certainly we've come off the Rouleau Commission with the Emergencies Act, and there's lots of people with opinions on that. But would you, kind of having experienced what you've experienced and what you've contemplated here today, would you agree that an inquiry that was granted unfettered access, including having not just the kind of constitutional direction from the House, but also the powers for documents and evidence and ultimately judicial oversight, do you believe that that would be a good, nonpartisan, non-political, unobstructed opportunity for us to deal with these matters of national importance when it comes to piercing the veil of cabinet confidence and the ability to pursue any types of allegations of wrongdoing? Would a public inquiry have provided the remedy that seems to have frustrated you in your ability to have a full investigation?
So, Mr. Chair, I would say that even with the public inquiry, I think cabinet confidence still applies, and that's something that you have to work out, but my understanding. So, again, a real short, I think cabinet confidence was set in place for a reason. I'm far from being an expert in that. I think it has to be reviewed as to why it was put in place and the interpretation of cabinet confidence as I discussed with the Honorable M. Villemeux.
That's very helpful. Thank you.
Thank you, Commissioner. Thank you, Mr. Green. Final 2 5-minute rounds. We're going to start with Mr. Brock, and I understand he'll be sharing his time with Mr. Cooper. Go ahead, Mr. Brock.
That's correct. Thank you, Chair. In the RCMP assessment report from February 2021, I've identified 2 items which partially explains the RCMP's reluctance to not continue the investigation. You referenced this as early. JWR, Jody Wilson-Raybould, did not think a crime was committed. She stated the Prime Minister's actions were inappropriate and unethical, but not criminal. Did the fact that she was still a member of Justin Trudeau's cabinet factor in that analysis?
To be honest, Mr. Chair, I'm not exactly sure if this was a factor.
Thank you.
In her determination.
Yet after Dion's report, she told the RCMP that information she read gave her cause for concern. Are you aware of that?
That's correct. Yes, Mr. Chair.
Is the RCMP in the habit of outsourcing investigatory decisions to non-investigators?
I'm not exactly sure about the question, Mr. Chair.
You seem to be relying upon the fact that she used the words, I don't believe Justin Trudeau's actions were criminal. That seemed to be a factor in your analysis. Are you saying that wasn't a factor?
Yes, of course it was a factor, Mr. Chair.
So the question is very specific. Do you generally outsource a non-police citizen to make that type of an opinion of a legal matter?
You mean from the former Attorney General?
Yes.
I would have to say that her testimony is important in the assessment of the overall situation.
She was a member of the Liberal Party of Canada. Of course she's going to say it's not criminal. She was hanging on to her job. Can't you see that as an issue here?
Yeah, I'm pretty sure she was.
Right? And she paid for her price because of her refusal to follow Justin Trudeau's lead in offering the DPA. I'll move on. Dion's terms of reference required him to shut down the inquiry if he discovered evidence of a crime being committed. Did that weigh in your decision as well?
Again, I would have to say, Mr. Chair, that this was not a determining factor.
Okay.
Again, it was based on the overall. This is one element amongst a
The
myriad.
Justice Committee, before it was shut down by the Liberal government, interviewed 5 witnesses. Ethics Commissioner interviewed 14 witnesses, yet you interviewed 4 witnesses. You did not interview the Prime Minister. You didn't interview anyone in his office, the PMO or the PCO. My last question to you is, you had the opportunity to interview Justin Trudeau and you declined, yes or no?
What I have to say, Mr. Chair, that this is an answer that's not a yes or no question. What I have to say is that when we look at this, of course, our purpose is to look for criminality. We need to meet that threshold before we can proceed to further steps. Again,
and everyone else had an interest in those witnesses except the RCMP. Thank you. Moving on to Mr. Cooper. 2 minutes, Mr. Cooper.
Thank you, Mr. Chair. Just to clarify for the record, the RCMP could not rule out criminal wrongdoing on the part of the Prime Minister, correct?
Of course, Mr. Chair, I would have to say that until we had a chance to look at everything.
It's at paragraph 23 of the conclusions and recommendations in the investigation report, so you can confirm that.
That's correct, Mr. Chair.
Okay. And was the RCMP hindered in its investigation when it drew the conclusion that there was insufficient evidence to further pursue the Prime Minister, including because of the refusal of the Prime Minister's personal department, the PCO, to expand the order in council?
So again, Mr. Chair, we worked within the parameters that were given to us and the regs that were given to us, and we did apply.
And the parameters were inadequate.
And we did apply to open through an order of council to have additional information, and it was refused.
It was refused by the PCO. And paragraph 24 of the investigation report states, however, should additional evidence be uncovered corroborating a criminal intent to obstruct justice, it would be recommended that the occurrence be reopened for further investigation. Now, I have a real tough time understanding, in the face of the obstruction that the RCMP was facing by the Prime Minister and the consequent lack of evidence to further pursue getting to the heart of the issue, that being obstruction, why the RCMP didn't see fit to even pick up the phone and contact the Prime Minister and schedule an interview with him.
Quick response, if you will.
Yes, I would have to say, Mr. Chair, in this situation, of course, again, we have to operate within the parameters of what we have. It's not to me.
There's nothing within the parameters that you had that would have precluded you from picking up the phone to contact the Prime Minister.
But again, we have to assess if a criminal offense has taken place.
Thank you. Ms. Khalid, 5 minutes. Go ahead.
Thank you very much, Chair. So just to recap what we've heard today, you investigated. You did not find any criminality or any wrongdoing. Is that correct?
Based on the information I've given. Yes, that's correct, Chair. Mr. Chair.
Yes. And we've talked about cabinet confidences and how there should be parameters around those cabinet confidences in balancing out transparency, yes?
And that, Mr. Chair, I'll leave it up to this table to determine what is appropriate.
Absolutely. And we also confirm that you have acted independently, not on behest of any political party or any organization in all of the work that you do.
As I said today, Mr. Chair, we did not brief anyone on this file at the political level once.
Thank you. And just to clarify something that my colleague, Mr. Cooper, said, he said that the PCO is the Prime Minister's personal department. Is that true?
Well, that's an opinion. I'll keep the opinion to myself.
Thank you. I really appreciate the time that you've taken. I think, did you have some questions? Yeah, I think I'm going to pass it on to Mr. Housefather. Thank you, Chair.
Thank you. Just a couple of brief questions, and thank you both for coming in. Do you always interview the targets of your investigation, or do you wait till there's a reason for that based on the analysis that you've done?
Before you sit down with someone, obviously there's an analysis that's been done of everything you collected on that person as to what have they seen, are they involved and whatnot. So people, our investigators have a game plan when they go in and sit down with someone, if there's a need to sit down with someone.
Right. So there was no predetermined decision when you started this investigation that you would or would not sit with the Prime Minister or anybody else, correct?
I would say to that, Mr. Chair, is we follow the evidence.
Correct. But see, there seems to be an attempt to make this an investigation about the Prime Minister. This is all about the Prime Minister. You were investigating a factual situation that involved a myriad of different instances and different people, and you came to the conclusion of who you wanted to interview or not internally without political pressure, correct?
That's correct.
Thank you so much. I'm done with your chair.
Hey, thank you, Mr. Housefather. Thank you to our witnesses today, Commissioner Duhaime, as well as Staff Sergeant Pinsence. I will tell you, Commissioner, that the clerk will be following up with the Secretariat to make sure that we get the information requested in an appropriate timeline. So I want to thank you on behalf of not just the committee, but on behalf of Canadians for being here today. Monsieur Villemure, sur la motion qui était adoptée.
Mr. Villemure, on the motion that was passed by the committee in October, the decision of the committee is for to have two meetings, and the witnesses that were proposed before the committee would be the former Conflict of Interest Commissioner and Ethics Commissioner, Mr. Dion, the interim Commissioner, Mr. von Finkenstein, and also the former clerk of the Privy Council, Mr. Warnick. I propose to the committee that perhaps later on in the month of April we can do this, because Thursday we're starting on the committee report for consideration, and following that we'll be able to have that testimony before the committee, perhaps later in the month of April. Yes, go ahead. Mr. Chairman, thank you very much for the clarification. I appreciate it. I would like us to give precedence to the former commissioner, and there's some confusion about the mandate I think that they can clarify, but there was one who was present at the time and the other took up his work afterwards. So I think if we're going to make one a priority, I think Mr. Dion, the former commissioner, would be my proposal to come first. Well, perhaps I could make a priority of all of the witnesses that we're asking to appear before the committee. The problem now is that we have only one meeting on Thursday, then we have 2 weeks in our ridings, and then another week in March. So perhaps in the month of March, we might be able to have some of the witnesses here. So that's the problem. It's a problem of the timetable, the House calendar, and for the committee as well. Okay, thank you very much. Once again, thank you to our witnesses for today.